ballot. These include, first, in subdivision 2B2 of the statute, that the voter sign the return envelope, not any person and not a voter. Second, ballot board members must be satisfied that identification numbers used on both the ballot application and the return envelope match. If they do not match, then election judge members of the board, and only election judge members of the board, quote, compare the signatures between the two documents to be, quote, satisfied that the actual voter returned the ballot. I would like to emphasize here that this is decidedly not a political examination. At no time during this review do the board members know for whom the person voted or their political affiliation. The secrecy envelope ensures that. The rule at issue replaces the statutory satisfaction of the ballot board members with that of the Secretary of State. As to subdivision 2, the Secretary's argument even contradicts his own rule, which contemplates a possible signature review, even if it is artificially limited to a name review. And the Secretary's argument in this case rewrites the language of the statute to require that board members only look to see that there is any mark on paper, even if the return envelope appears on its face to be a mismatch with the ballot application. As to subdivision 3 of the statute, the rule allows for a number of exceptions which swallow the statute whole. It should be noted here that the signature match in subdivision 3 is a method of saving absentee ballots from rejection. It's not a catch-all to allow acceptance of all ballots no matter what. But the rule allows for mismatched signatures to be accepted so long as it's conceivable that one person was signing on behalf of the other. Yet the rule says that a different signature on either document is not a ground for rejection. By telling absentee ballot board members to be, quote, satisfied that, quote, the voter signed a return envelope, and, quote, satisfied that identification numbers match, or that the same person signed both the ballot application and return envelope, the legislature specifically instructed Minnesota citizens to use their good judgment to decide that a ballot was cast by the voter entitled to cast it. The court should strike down the rule because it forbids the use of that discretion and thus operates as an unlawful amendment to the rule or to the statute by the Secretary, who has no such authority. I would welcome your questions.
Counsel, I want to ask you about Section 203B.125. That's the provision where the legislature gives the Secretary of State authority to write rules. I don't have the language here in front of me, but let's see, maybe I have it here somewhere. For issuing ballot cards and related absentee forms, etc. As I read your argument, sometimes in these sorts of rulemaking cases, we see arguments where the appellant is saying the government entity went beyond the scope of their power under the Enabling Act. I don't see your clients making that kind of argument, but I wanted to just get your response to that. I mean, is this an argument based on the Enabling Act, some Enabling Act, maybe not the one I cited, but some other one? Or is this is a more classic argument about the rule just conflicts with the statute?
Well, we have expressly made the argument, the latter argument that you have identified.
You have made the latter argument.
We have made the argument that the rule conflicts with the statute repeatedly, but I have looked at the statute that you're referring to again recently, and I would note that there is nothing in that statute that does expressly authorize the Secretary of State to make rules specifically related to the process in which a ballot board member reviews an absentee ballot. So it does appear to be that we haven't raised that issue though in this case.
Okay, that's helpful, thank you. And then if we hold that the statute, and when I say the statute, I mean 203B.121, if we hold that the statute does not require a signature comparison in every instance, does that mean that your client loses?
No. No, in fact, we agree that under subdivision 2B2 of the statute, and we've argued that in our briefing, that the opportunity to conduct a signature match by the individual ballot board member is what the legislature allowed. By saying the voter signed, that's what they have to be satisfied of. That means in that instance, the ballot board members should be able to, considering the information they have in front of them, take a look at both documents to see if there's a match.
So it's up to their discretion is your argument, and the rule conflicts because it takes that discretion away.
Correct.
Yeah.
And beyond that, I mean, there are situations in which there would be, online applications which don't actually even have signatures on them. And that whether that's a bug in the Secretary's processing system for applications or not is not at issue here. But if there is no signature to look at from the ballot application and there's no signature in the voter record, then it's not conceivable in our view that the legislature would have required a signature match under 2B2. However, it is required under 2B3 if there's an identification of a mismatch, and both parties agree with that.
Then one last question for now, and then I'll let my colleagues jump in here. But so I'm going to refer to, so there's a provision in the rule, use of or lack of full names, nicknames, abbreviations, or initials. I'm going to just refer to that as the nickname provision. How does the nickname provision conflict with the statute?
Well, if someone is using the nickname is a different version of a legal name. And so if someone, signs their signature as, and I'm just making stuff up at this point, John Smith, and then they sign it as Jack Smith in the next one, and the handwriting looks different as well, you could see a situation in which they should be allowed to reject it based on their discretion, but they can't because the only distinction that is objectively there is that there's a nickname being used.
There is support in our law for this idea that if rules are a reasonable effort to implement the statutory directive, that there's not a conflict and those rules will stand. You agree that that principle of law is out there in our cases?
Well, I would modify that slightly to say that if so when we're talking about agency deference,
yes,
right? In that situation, you're talking about rules like, for example, boards of licensing or the MPCA or other agencies have this ongoing implementation and enforcement every single day, where they're issuing permits and that kind of thing. The case law, I believe, states that that's one of the criteria, that it's something that the agency is doing all the time and implementing on a statewide basis consistently. I don't see this rule as being like that, in that it's not constantly being enforced by the secretary on a daily basis. So I don't think the agency deference actually applies at all here, but the agency deference certainly doesn't apply in the situation if you have an unreasonable interpretation of the statute, which is what we claim that there is.
But how is that unreasonable? I mean, a nickname. I mean, so if I write Lori Gilday and then I write L Gilday, I mean, how is that not reasonable? It just, how does that conflict with the statute? If the question is it my name?
Well, the question is it your, under 202B3 at least, is it your signature? But if you're looking at for example, the application and the return envelope and the voter record, and you've never before signed it with L Gilday, I would imagine that might raise at least a red flag. Now, mind you as well, there are safeguards to protect an improper rejection, including that there's more than one person who's reviewing each one of these signatures. And under 2B3, they're actually party balanced at that time because they have to be election judges reviewing it. So the legislature has already taken into consideration that, something that is substantially similar between the two signatures is not going to be rejected. And I think that's what the other statutes related to the UOCAVA board and similar situations already provide. So, from our perspective, what you don't want to have happen is the situation that's occurred here, which is where the Secretary of State has said, you cannot consider this, you cannot consider that. It's what we call a reverse mandate, whereas the legislature has been silent as to whether or not there is, as to the method in which each individual board member actually reviews the ballot. The Secretary says, you may not do this, 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 and this. And so taking away that discretion, and when the legislature is silent as to how to implement the language of the statute, it implies strongly discretion. When you take that away, then you have a conflict.
But counsel, that theory seems to contradict, to me at least, just the plain language of the statute. And because in subdivision 2B3, it talks about the ability for the election judges to compare signatures, but you don't have that language in 2B2. And so I'm just having trouble getting over that, because we have so many cases and in our rules of canons of statutory interpretation that say if the legislature had wanted to say that, if they had wanted to have signature comparison be a part of the entire statute, they would have put it in there, and they didn't. And so help me get by that.
Yes, Your Honor, and I think that, so
Which is what the Court of Appeals said. I'm essentially tracking what the Court of Appeals said.
Understood, and So we're talking about, is this second signature match a surplus, basically? And the answer is no. And we don't dispute, for example, the legislature in 2010 changed the language of the statute to create both subparts 2 and 3, where there previously was just what I would call, or subdivisions 2B2 and 2B3. Previously it was just 2, and it talked about the genuine signature, and it took that away as it relates to the voter signed the certification on the return envelope. Right. But this court's jurisprudence on the use of definite articles, the definite article of "the" in this case, I think overrides any concerns about surplusage in this case, because the court has, in the Rodriguez case from 2019 that we cited in our reply brief as one example, the court used that definite article of "the" and said when it's referring to a specific object in the statute, we don't presume that somehow, some argument about a surplus result is dispositive.
I tend to agree with you on the definite article "the." I tend to think you're right on that. I just don't know that that gets you all the way.
Right.
Because I think you still have to deal with the very specific language in 2B3, and I don't know if that's surplusage. I just see that as kind of plain language, and even if there's some ambiguity, when you get to the legislative history, your position just seems to totally confound what the legislature wanted to do. I mean, after the Franken-Coleman brouhaha, it was very clear, it seems to me, that what the legislature wanted to do is that we don't want to go there again. We're not going to do this signature matching thing. We're going to get out of that business. We're going to make it more objective. We're going to have you just match up the numbers. And so when I put all of that together, I'm just finding it hard to see where your position gets me.
Well, Your Honor, if I can point to a couple different parts of the legislative history. I mean, I would like to talk about the plain language as well, but quickly on the legislative history, Senator Sieben and Representative Winkler made statements on the Senate and the House committees related to this, and they did say this is intended to replace the signature match. But at the same time, then Representative Kiffmeyer, former Secretary of State Kiffmeyer, said in a committee, House committee meeting, that the point of this is not to get rid of a signature match. It's designed to make sure that there is both acceptance of correct ballots. Yes.
Let me ask you this way. I thought that the ACLU's amicus brief laid out that history well. Is there anything in that legislative history that they laid out that you dispute?
Off the top of my head, Your Honor, I don't recall. I'm sorry, I can't answer that directly.
One last question, and then I'll stop. Thank you, though. If we, and this is just sort of a practical boots on the ground kind of question, but if we agree with you as to either 2B2 or 2B3, and we say that the rules are inconsistent with those statutes, what happens? What does the state have to do? What does the Secretary say? I'm just trying to figure out when you walk out the door, if you get that ruling, what happens?
Well, I think, first of all, that the Secretary doesn't have to do anything. This court in the 2009 Sheehan versus Franken case made it very clear that even the previous completely signature matching law that was in place was a uniform law that was not subject to varying interpretations or differences across the state, and it must be followed with strict adherence by all voters. So the legislature has already created a statutory scheme that is uniform, that is reasonable, and that this court has.
So they don't have to change the rule if we say it conflicts, or they don't have to have a rule? Or?
I don't think they have to have a rule at all. Because this rule was made out of whole cloth. It wasn't even part of the notice and comment period in 2009 when it was originally introduced. This was made out of whole cloth in 2010 after the statute was created, based on a suggestion actually by the Republican Party of Minnesota's lawyer that then morphed into something different.
And then if they want to have a rule, what do they do in your mind? I mean, I'll ask counsel too, but
Sure.
What do they have to do then?
I think they just go through rulemaking again.
You go through the regular?
Absolutely. Yeah, they have every right to go through rulemaking to address this and to change the language of this to make it, consistent with the statute.
Okay.
Counsel, I wanted to ask you, I have a couple of questions about the plain language. When I look at 2B2, the introductory sentence says that ballot board members would be doing that, looking to see the voters sign the certification. And of course, that can include members who aren't election judges. And then when you look at 2B3, that's specifically limited to election judges who have to be partisan, one each side of major parties. And so doesn't that show us that when the legislature wanted to assign this duty of comparing signatures, trying to see if they're genuine, that it assigned it specifically to election judges only when, the numbers, the identification numbers didn't match?
I think it's certainly the case of what you described, that the legislature did choose to assign it to election judges because when there's an ID number mismatch, they required a signature match at that point done by election judges because of their partisan balance. But I don't think, again, that is a surplus check or anything like that. Because remember, every single ballot that's looked at, if it's always looked at first by ballot board members based on this court's decision in the Minnesota Voters Alliance versus County of Ramsey case. So whether they're election judges or not, they could be, right? But every single ballot is looked at initially. And if so there's at least, when there is an ID number mismatch, there is always going to be two sets of people reviewing it. So there's nothing wrong with having two different sets of ballot board members reviewing an individual ballot, first of all. And then secondly, the ballot board members themselves still, the legislature, by using the language, the voter signed the return envelope, I think entrusted those members also to have an opportunity, if they're not going to be the subsequent group reviewing it, to take a look to see with the information they have available in front of them, does this appear to be the same person who requested the ballot?
And of course, subdivision 2B2 doesn't say anything about looking at, it just says the certification on the envelope. It doesn't say anything about the application.
Correct. And what we believe that implies is that if you're trying to figure out if it's the voter, you have the ability to look at certain information in front of you, which includes the application, includes the return envelope, it includes the voter record and the SVRS at least. And so if you're looking at the return envelope signature, you're also going to have that information in front of you, just as a matter of course. So it's not as though they have to go digging for it to do a signature match on every single ballot at all times. It's a matter of what information they have in front of them. They're entrusted with their discretion to address whether or not a ballot should be accepted, and they can use that discretion according to the legislature.
I also wanted to return to the fact that the legislature in 2014 permitted online applications.
Yes.
Where voters don't even, there is no signature to look at. And it seems to me that came after, and if 2B2 is read the way you intend, it seems like that blows a huge hole in that argument.
So first, I would say, I don't agree, of course, but I think that there is, first of all, unless the person is registered for the very first time in that election and they registered by online application and then they submitted a ballot application via online application, in that case you wouldn't have a signature on record. In every other case where someone has signed up to vote by registering, whether it's through Motor Voter or whatever, you will have a signature on record. So you would have something to refer to in the voter record, whether it's on the application itself or not. And that's part of 2B3. It's actually a feature of 2B3, is that even if there is a problem with the signature on the ballot application, the election judge can look at the voter record to determine whether or not there's a match between the signature on the return envelope and in the voter record. And that's designed to save ballots, which could otherwise be improperly rejected on the basis of signature. So if that information is there, then the online voter application doesn't have a problem. In the situation, the very narrow situation in which a person signs up to vote online and they also get a ballot online, you wouldn't have a signature to compare it to. And in those situations, this is why we believe the interpretation must be that it's not mandatory that there be a match under 2B2, but that it's permissive. And so there's no conflict there.
Counsel, what do you say to the policy arguments that the state and amici make regarding just the inherent unreliability of signatures and how signatures can change? And I think we all can attest to the fact that when you look at your elderly parent's signature sometimes, it really varies. Or mine. It really varies, and, and as we get older, it changes. Or there are arguments that, people with disabilities may not, so you're not always going to have that matching, and it just, I don't know, it raises a concern in my mind that we might be, under your theory, discarding valid ballots.
So I think first and foremost, if we are evaluating the merits of signature matching itself, that makes it clear that the Secretary's rule does in fact conflict with the statute, because the legislature has required a signature match. And the Secretary's rule itself also...
Yeah, I was going to say,
In paragraph 3?
Yes, it's required in 2B3.
I don't disagree with you about that. I think that's clear. I'm talking more about in 2B2.
Oh, okay.
Because that's what I hear you saying, is that your clients have the ability to do signature matching there as well.
Right, but there wouldn't be any difference in the signature match. If they wanted to do a signature match under 2B2, there wouldn't be any difference between the method that they would use between 2B2 and 2B3 necessarily. So what I think is most important to emphasize, and I think fairly refutes the amici's concerns and the Secretary's concerns on policy, is that Minnesota has a really robust setup to where you can cure any defects. You can fix an improperly rejected absentee ballot very easily. We detailed this process towards the end of our reply brief. I don't want to get into every single thing of that with only 20 seconds on the clock here. But,
one more question, Chief.
But the last 10 pages of our reply brief, I think, really get into this issue. And I would just say Minnesota's robust statutory protections for individuals who are potentially dealing with an improperly rejected ballot are there for their safety.
Hang on a second, Justice has another question.
Yes.
One last question. On 2B3 and whether or not the rule violates, well, you say the rule violates that because the rule allows for ballot board members to do the comparing of the signatures, whereas the statute says it must be election judges, and then you refer us back to our original MVA 1 case where we made it clear that that's the role of election judges. But I wonder, it almost feels a little like a tempest in a teapot to me, because it's very clear that election judges are a subset of the ballot board. And as you say, the statute is clear that has to be done by election judges. And I'm just wondering why we're all wound up about it.
Well, we're not too wound up about it because we didn't spend a whole lot of time in the brief talking about it. But we raised the argument because it does show a conflict between the, ballot board members and election judges are two different categories of people. Yeah. And it's specific in the statute, and that's what this court decided. So it's important that the rule doesn't potentially supersede that to allow for general ballot board members to do those matching.
Thank you, counsel. We'll see you on rebuttal.
Thank you.
Mr. Barr.
May it please the court, I am Assistant Attorney General Alan Cook Barr. I represent the Secretary of State in this matter. November 4th, 2008, Minnesota held an election for United States Senate. 8 months later, in what was the largest and longest recount in Minnesota history, that election was finally decided. A substantial issue leading to that 8-month duration was the treatment of absentee ballots, particularly the rejection or acceptance of absentee ballots due to signature comparisons. In the wake of that recount, Minnesota amended its absentee ballot statutes to prevent it from happening again, and bringing uniformity to how absentee ballots were treated in the state by moving from a signature match to an identification number comparison. 14 years later, appellants have brought this case to try and move Minnesota back to that old signature match system. Appellants present two categories of claims. First, how ballot board members review signature envelopes when identification numbers do match. Second, how ballot board members review signature envelopes when the identification numbers don't match. Appellants' claim with respect to when identification numbers do match is premised on the language requiring that ballot board members be satisfied that the voter signed the certification. But there are three reasons why that interpretation is incorrect. First, the statute envisions situations where the voter receives marking assistance, so the voter signed cannot mean that the person whose vote is being cast must also sign. Second, it would render language in 2B3 superfluous. And third, it would contravene federal law. With respect to when identification numbers don't match, the statute doesn't say how comparisons are to be performed. The rule does. Appellants claim this is a conflict. But for there to be a conflict between the rule and the statute in the way that appellants suggest, statutes would have to expressly permit comparisons to be performed in the way that appellants suggest, while the rule would have to prohibit that type of comparison. That's not what we have here. Instead, appellants are making up out of whole cloth how comparison should be done with no source in law. Because of that, it has no basis in law. It would lead to disuniformity throughout the state in terms of how ballot boards treat absentee ballots. Beginning with general authority when ballot identification numbers do match. Appellant's argument is that ballot board members have general authority to compare signatures even when numbers match turns on the meaning of the voter signed. There are three reasons why this phrase unambiguously means that there is a name or mark on the line to indicate acceptance of the certification that the individual is in fact old enough to vote, that they haven't had their civil rights taken away, that they live in the area where they're voting, and the name is clearly not someone else's name.
Counsel, I'm just going to stop you because your 3 minutes are up. And I want to ask you about one of the conflicts that's alleged here. So under the statute, under subdivision 2B1, the ballot board has to be satisfied that the voter's name is the same. The name on that signature envelope is the same as the information provided on the application. But the rule says that the ballot board can't use the fact that the name is different due to the use of a nickname as a reason for rejection. That seems like a conflict to me. I mean, the legislature didn't say using a nickname. The legislature said you got to see if the name is the same. And the gloss that the Secretary of State's rule is putting on it is narrowing, I guess, in a way, what the name is. And I'm just wondering, isn't that a conflict?
I don't think that's right, because the name appears twice on the signature envelope. If you look at in the record OSS 1823, there's a picture of what the signature envelope looks like. And that name language in A is dealing with the not where the voter signs their name, which is lower on the certification, but the name section at the top. Whereas the Secretary's rule that appellants are challenging, that's dealing with the signature. So if you look at the rule, there's sub 2, the voter's name and address on the absentee ballot application must match the voter's name and address on the signature envelope. They aren't challenging that first paragraph of the rule. Then we get to the second piece of it. That's where they're challenging with respect to the signature match. And that is where they don't have the authority to reject ballots based on the signature comparison.
Sorry, maybe I'm asking a different question. I mean, it just seems like the statute says the ballot board should look to see if the name is the same. And the Secretary of State's rule is saying you're not really looking to see if the name is the same, because in fact the name can be different. If you use your full name on the application but you use a nickname on the envelope, your name is the same. That feels like a conflict to me. Now maybe I'm misunderstanding. Are you talking about where they're printing their name at the top, or where they're signing their name on the envelope?
Okay. So with respect to where they are printing their name, first I would note appellants, I don't believe are challenging the printing. They're only dealing with signatures. But with respect to where they are printing their name, the statute says that the voter's name must be the same. However, it doesn't make clear what same means. Does it have to be virtually identical if someone were to write?
But I mean, just as a matter of common sense, right? I mean, we all know if your name is the same. I mean, it's Alan. It's not Al. Alan is Alan. Lori is Lori. It seems like the Secretary is sort of, and I'm not suggesting there's any bad intent here. I'm not suggesting that at all. But it just seems like a conflict to me.
Well, first, I mean, I would note again, appellants haven't challenged under that first section. But with respect to the names, for example, I wrote Alan Seabar versus Alan Barr. Are those the same or are they different? The Secretary's rule provides guidance on what same means because that term isn't defined in statute.
Yeah, that's a really good point, very helpful. So what about let me ask it this way. If we conclude that there is a conflict because in paragraph 3 of the statute, it refers to election judges, but in your rule, not yours, but in the Secretary of State's rule, it refers to ballot board members. If we say that's a conflict, what happens then? What's the next thing that happens in this case?
If that is a conflict, then I believe the court could solve the issue by telling that, I think, issuing a form of declaratory judgment that the rule be narrowed to only apply to election judges, because as Justice Hudson noticed, it's a subset.
We could sort of blue pencil it in a way.
Yes, I don't think you would need to throw out the whole rule. The court's already recognized that only election judges can perform this task, and the rule doesn't say ballot board members are explicitly authorized. They would follow the statute. Only election judges would be doing the work. But I don't think that even makes the rule a conflict, because the rule says ballot board members, the statute that then gets more specific. It's possible to comply with both.
But that's not the test, I don't think. I mean, in Dunham, which is cited in the briefs, it was possible to comply with both because the statute was 90 and the rule was 45. So if you did 45, you complied with both because 45 is part of 90, at least according to my math. So you could comply with both, but we still said that's a conflict. The rule is out. Isn't it the same situation here?
Yes, I think it is analogous, but in light of this court's prior ruling in MVA v. Ramsey County, this is already being done because and ballot board members are, as far as the Secretary knows, complying with the statute and not having non-election judges do it going forward. Getting back to ballot board members' authority in general when the identification numbers do match. So I mentioned there are 3 reasons. First, the voter sign cannot mean that the person whose vote is being cast must sign, because the statute in other sections, specifically 203B.03 sub 1A7, authorizes someone else to help mark the signature envelope. If the legislature intends for others to mark the signature envelope, then the voter sign cannot mean the voter whose vote is being cast. Second, the very next paragraph has explicit instructions on when comparisons are to be performed. Those instructions aren't in the voter sign paragraph, and it's noteworthy that the legislature used specific language when they were saying how comparisons are to be done. They didn't put that in paragraph 2. When the legislature uses different language, the court assumes the legislature means different things.
So is it your position, I mean, I think it is, but in terms of rulemaking, could the Secretary draft a rule that allows discretion to do signature comparison and not be in conflict with the statute? Would they, I mean, that's not the rule that's been adopted, but could a different Secretary of State do that?
Under 2B2, the Secretary's position is no. There is no signature comparison under 2B2. Under 2B3, the Secretary could, he has.
Even though the language, and that's just because of the specific language in 2B3.
Yes,
That's
2B3, we agree with appellants under that.
But that's the main reason why. I mean, because without that language in 2B3, the voter signed the certification on the envelope. That seems like it could allow a signature comparison.
Yeah, yes, it does. I think it requires a signature comparison under 2B3.
No, under 2B2.
Oh, under 2B2.
I mean, setting aside the specific carve-out in 2B3, just reading 2B2, that would allow. But your argument then is that because of 2B3, you can't do it. Because
of 2B3, because of the fact that other sections of the statute say that other people can sign the signature. And then third, because it would conflict with federal law, 2B2 cannot require a signature comparison. Briefly on that federal point, as this court is well aware, when interpreting Minnesota statutes, we assume the legislature wants them to be enforceable. If they're preempted by federal law, they wouldn't be. Federal law says that voters can get marking assistance. So once again, there's clearly a command that someone other than the voter can sign the signature envelope. For those three reasons, this statute unambiguously does not require that the person whose vote is being cast to sign the signature envelope. But even if the court concludes it is ambiguous,
It's not your position that outside the context of a voter who's unable to write, I mean, it's not your position that anybody can just sign, right? I mean, it has to be the voter who's signing. Outside that context, where the voter is unable to sign. Or
yes, if the voter has not received marking assistance, if Justice Anderson votes and I steal his signature envelope and I sign it instead, that's no good. But
if they can read your signature, it's not my envelope.
excuse me.
I mean, the voter has to be the one, other than this context of someone who needs assistance, the voter has to be the one who does.
Yeah, either the voter or someone authorized by the voter to provide marking assistance, yes.
Counsel, I had a standard of review question. This is a pre-enforcement proceeding, as I understand, challenging the validity of this rule. And I noticed some law from this court that indicates that the pre-enforcement proceeding standard of review is a little more restricted than an appeal from a contested enforcement proceeding. And I don't know if that has any bearing on this whatsoever, but there is some old law in this state that discourages broad and far-reaching scrutiny of a rule based upon hypothetical facts as being sort of a, premature exercise of judicial authority. Now, the Secretary has conceded that the standard review here is purely de novo. This is just an academic exercise of reviewing the language in the rule and the statute. Is there any reason for us to be cautious in our review here based upon scenarios that are being brought forward about how these rules could or couldn't be applied?
I can't point to anything specific for caution, Your Honor. The court should, of course, I think, always be cautious in declaratory judgment matters that you're dealing with hypothetical situations. You don't know exactly how things are going to play out in any particular scenario, but beyond that general caution, no, I don't have anything really to add to that. If the court does conclude that this statute is ambiguous about whether or not the voter has to be the person whose vote is being cast or someone else, every tool in the ambiguity toolbox is clear that it can be someone other than the voter and there is not a signature match. If you look at the events surrounding the passage of the law,
Is that really what the Secretary of State wants the law to be, that it can be anybody, it doesn't have to be the voter?
no. No.
I mean, that argument just feels a bit extreme to me.
No, it should be the voter or someone providing marking assistance to the voter. But in terms of whether you're doing a signature comparison at this stage.
I think that's the horse you want to ride.
Yes. I think if you look at the events surrounding the passage of this law, however, the Frank and Coleman election, the 8-month recount, the fact that the prior statute used the phrase genuine signature at this stage and the current one does not. Statements by legislators that they were moving away from a signature match, they were moving from a signature match.
Point, we heard from opposing counsel there were some legislators who have a different view on that. How do you respond to that?
I was just about to get to that. There is one statement that opposing counsel points to with respect to that this is not just about accepting wrongly rejected votes, but it's also about fixing wrongly accepted votes. That statement, to my recollection, was not made specifically about absentee ballots, but about the statute in general, which dealt not with just absentee ballots, but a whole host of other election issues.
Do you know was that Senator, or how?
I believe it was Kiffmeyer.
Do you know how she actually voted on the bill?
I do not.
I mean, doesn't
I
that
believe
matter?
I think it was almost uniformly supported, but I can't say with certainty that it was uniform. I don't know.
We don't know, okay.
I know it was had broad
Do we
multi-party
know
support.
whether she was an author of either bill?
That I also don't know off the top of my head.
Because that matters, right?
Author intent is certainly one relevant tool, but the other non-authors, to the extent they made statements, also matter.
Mr. Barr, before you go further, I want to just back up to a little bit of your exchange with the chief. I just feel like there's kind of an elephant in the room, and we're kind of dancing around it. Well, one of the concerns here from your opponents, and it comes through in their briefing, is that there's the potential for these just random people to be signing off on behalf of a voter. And outside of this context where, there's the marking assistance kind of context, what's your response to that bigger picture policy concern, and how does the rule deal with that potential that everyone is concerned about, but no one wants to say?
There are a host of protections to ensure that people aren't voting for others. So if you look at the Secretary's brief, we lay out in detail the steps you would have to take to get to the phase of voting on behalf of someone else. First, you would have to register to vote. That's a felony if you do it under someone else's information. Then you have to apply for the absentee ballot. That's a felony if you do it under someone else's information. Then you have to cast the vote. Again, you have to sign the certification. That's a felony. Moreover, after the fact, let's suppose that someone goes through those steps and is willing to commit all those felonies. Come election day, the individual who actually wanted to vote in person, or maybe they wanted to vote via their own absentee ballot, the statewide voter registration system is now going to have a record that both the individual submitted one absentee ballot from whoever was faking their vote, and they tried to submit either a second absentee ballot or vote in person. That's going to flag then for further follow-up that one of these votes is fraudulent, and then election judges can look into and determine, or county attorneys, whoever the appropriate enforcement authority is, which vote was actually the person's, and you can take action then against whoever was voting improperly.
There's nothing specific in the Secretary's rule that one way or the other adds to that equation, makes it easier or harder?
No. Those other tools come from other statutes, but are designed to get at exactly what appellants claim is the concern.
But what if I have my parent living with me, they forget to vote, I see the absentee ballot sitting on the counter, and decide I'm going to vote that one too? I mean, none of the scenarios you talked about address that.
No, so in that instance, yeah, so you'd cast your vote on I guess it would depend on the timing. First of all, I mean, if you see they forgot their ballot, it's election day, you could there'd be timing issues with getting it in time. But putting that aside, in that scenario, you would still be committing the felony, though, of voting on someone else's behalf.
But how would you ever find that out?
It would be difficult. It would be difficult. But I mean, on the flip side, yes, it would be difficult in that situation. However, you would have to know still, and one of the other protections I guess I didn't address then is identification number. You'd have to either know their social security or their driver's license number. Now, you might know that because you're a family member, but that is another protection that is there. Moreover, if the identification numbers match in that scenario, under the Secretary's view, you aren't even reaching the signature match that according to appellants, would solve the issue. Because in that instance, the ID numbers match, there's a signature on the envelope, so that appellant's view, or the Secretary's interpretation at least, and the interpretation that is clearly supported by the statutory history would say that you aren't doing signature comparison.
But I think under appellant's view, unless Justice Thiessen can closely match his parent's signature, they would, on the application, under appellant's view, the ballot board members would catch that because they would be looking at the signature on the application of the parent, and it's going to be really different than the signature on the envelope.
I mean, yes, it would depend on how closely someone could match the signature, and that gets to the policy arguments that our Secretary touches on, and the ACLU goes into in depth, that signature matching is not a great system to detect fraud because signatures vary from time to time. That's why Minnesota wanted to primarily go to identification number backups and only use signatures when, well, we have to because the identification numbers don't
Fundamental
match.
problem here that nobody, I mean, none of this deals with, the fundamental problem is that absentee voting in any context creates ballot security issues that are not present when you vote in person.
That's true. The legislature chose, though, to allow absentee voting, and they weighed the pros and the cons of it and decided that absentee balloting and having Minnesota maintain its historic tradition as having the highest rate of voter turnout in the country was better than potentially disenfranchising people that can't make it to the polls.
And there's no challenge here about the standard that the Secretary chose for this sign is clearly different, which is not stated in the actual language of the statute?
No, I don't read Appellants' brief as
Okay.
raising that challenge. If anything, I think Appellants would like it to go further and be able to reject ballots even when it isn't clearly different. Yeah. I do want to go back briefly to the legislative history because I didn't quite finish my point on Senator Kiffmeyer's comments. The stat, at the time it was enacted, one of the other issues was with acceptance of wrongly accepted duplicate ballots. It's not clear what Senator Kiffmeyer was referring to, but that is one entirely consistent possibility that in saying we need to deal with wrongly accepted ballots, she was referring to wrongly accepted duplicate ballots. And if you look at sort of press coverage at the time, that was one of the things that was discussed that this statute was also going to deal with. I do briefly want to touch on authority when the identification numbers don't match in the remaining minute and a half or so I have. MVA contends that there is a conflict between the rule and the statute because the statute says do comparisons but doesn't say how. The rule then does say how. That's not a conflict. If you look at the dictionary definition of conflict, it means that it's impossible to comply with both, and that's also how this court has consistently treated conflicts in other areas, such as between statutes and city ordinances. Here,
But isn't the, I don't think preemption, case law applies in this context. I mean, we're not talking about, subordinate branches of government or something like that. I mean, here it's an agency in the legislature, so I think
it's not exactly on point, I agree, but I think it's a useful analogy that in some instances, the legislature enacts statutes and says cities can enact ordinances so long as they don't conflict. Here, the legislature enacted this statute and then gave the secretary authority to engage in rulemaking to reasonably carry it out. And I think that's a useful analogy. Under Appellants' reading, however, there would be no limiting principle on how ballot board members could do their comparisons. If a ballot board member went off on a wild hair and said, I'm going to bring in 2 divining rods and read the aura of each signature, and one of them's blue, one of them is red, and I'm going to reject them even though they otherwise look identical, under Appellants' view, there would be nothing to prevent that. That cannot be the law in Minnesota. Rather, the secretary can implement reasonable rules in terms of how signature comparisons are to be performed. So long as those rules don't conflict with the statute, they're an acceptable rule.
Thank you, counsel. Your time has expired. Let's see, Mr. Dickey, you have 13 minutes for rebuttal.
Mr. Dickey, when you're ready, could you just address that last point about how there wouldn't be any limiting principle on the election judges who would be comparing signatures?
Yes, thank you, Your Honor. So there would be limiting principles. First of all, the legislature has asked to compare signatures, not to compare auras or to look at the color.
How similar is similar? It just seems like there has to be some standards, or you could have you could just have varying perceptions about, what's the same signature in varying locations.
As with any anything where humans are involved in the process, there certainly can be variances in the way that people would look at a signature. That's, I think everyone understands that, common sense. But in this case, there's a couple safeguards that prevent the situation that we hear the Secretary talking about. First, there are more than one people who are looking at each individual ballot. It's the members of the ballot board who are reviewing the ballot, not the one person. And there has to be a majority that agrees to accept or to reject a ballot. So if you have one person who is not particularly well fit to be a ballot board member and decides to compare auras, for example, that would not carry the day. So the person's ballot is going to be secure there. Secondly, the statutory language, when it talks about comparing to determine whether it is the signature of the voter, that inherently has a directive for people to follow. And it's the same way that when the legislature says to turn left from the left-hand turn lane, it doesn't tell you which lane to go into, but you have discretion as to figure out exactly which lane you want to get into. So again, the legislature has provided this discretion, even if it's not something that the Secretary is particularly thrilled about. But furthermore, with regard to the differences, I think that the position that we have advocated is that what the legislature means is that you should accept, like they say in 203B.24, when signatures are substantially similar. And I think that that's what, when you're comparing things to determine whether they are the same person, you would inherently understand, as Chief Justice mentioned earlier, that there could be changes in someone's signature over time, but substantial similarity is what I think the legislature is required under 2B3 specifically. So I don't really see this concern about a lot of differences across the state. And I'd also note that this court, again, I mentioned it before, in 2009, in Sheehan versus Franken said, signature matching itself is a uniform process. What the Secretary is advocating for is uniform outcomes, not a uniform process. Signature matching is a uniform process. This court has expressly approved it and also required that those who are exercising the privilege of absentee method of voting to exercise their fundamental right to vote must strictly adhere to the requirements for absentee voting. And so, when the ballot board members in the 2008 recount were looking at ballots, it would have been great news to the challenger in that lawsuit that they don't have to strictly adhere and that they could just, these ballots could be reviewed again under a lesser standard than what the challenger was advocating. But that wasn't what this court decided. So again, adhering to these strict standards, including signature matching, what it means to match signatures, is a uniform process statewide, and it's not going to result in substantial disparities across the state, especially when you do have the ability to look at a ballot and say, okay, well, the identification numbers do match. You have a voter record in front of you. There's signatures that are in that voter record, like we talked about earlier, if the person has signed anything before. So there are a lot of different safeguards that prevent the situation, the parade of horribles that the Secretary has raised.
Could you respond to the Secretary's argument that if we adopt your interpretation, the statute would violate federal law?
Absolutely. Yeah, there's, again, 32 states have signature matching requirements. What the courts that have struck down different signature matching requirements under the Voting Rights Act have said, and there's, I think, 2 cases that I've seen, or maybe 3, but the ACLU in their brief put together a list of different cases where there were concerns about, some of the cases were concerns about signature matching. We have a footnote in our reply brief that I would point the court to that exhaustively goes through every single one of those cases and points out reasons why that's not dispositive in this case. But also, I mentioned in my previous argument that there is significant, robust safeguards in Minnesota law to protect against a violation of the Voting Rights Act. And specifically, there are notice and cure provisions. And I've got a couple examples that I'll provide the court. Again, these are in our reply brief, but I think it's worth noting that if a ballot is rejected before 5 days before the election, that the ballot board must promptly provide a new ballot. And if it's rejected within 5 days, the ballot board actually has to call, has to email, has to do whatever they can to get a hold of the person to let them know that their ballot could be rejected because of a signature mismatch. And absentee ballot board members are constantly, from the start of absentee balloting, 46 days before an election, they are constantly, within 5 days of the time a ballot gets in, they're reviewing it. So there's a timely, rolling basis in which they were reviewing signatures reviewing, whether it's signatures or identification numbers or both. They're reviewing them constantly in that 46-day period. Those provisions under Minnesota law are simply non-existent in like, for example, I think in Indiana was one of them, and in Florida. So we just have a different law here that doesn't violate the Voting Rights Act. Even if you had a straight signature match and no identification number mismatch, the signature matching would not, even absent the Secretary's rule, would certainly not violate the Voting Rights Act.
Counsel, just a kind of related question, and as I'm thinking about it now, was probably more appropriate for Mr. Barr, but one of you mentioned in your briefs, and I think it was the state, the training requirements that ballot board members undergo. Do you know what that is, particularly as it relates to signature matching?
So this is where, we lament in our brief the fact that there really isn't any signature matching guidance provided by the Secretary. We would encourage that. We think that would be a great thing if the Secretary were to actually provide some guidance as to how exactly you look at a signature to see the discrepancies between the two. I think that would be very helpful. 203B.121 subdivision 1 provides, and the legislature just did this in 2021, I think, provides for additional training for election judges and ballot board members. But I'm not aware of any particular training on signature matching that has been implemented as a result of that change in the statute. And I think it would be a positive thing. One thing I do want to make sure I address here is this concept of somehow the voter means can only mean literally the same person who requested the ballot. We've not said that in our briefs. We recognize under Minnesota statute 645.44, which would apply in these situations, that a person who has a writing disability, who cannot write their own name, can use a mark, can use a stamp, can have someone else sign, and that under the statute is expressly stated that signature is adopted for all purposes by that person. So it is the voter's signature. Our position simply is that under 2B3, for example, when you're comparing the application and the return envelope, and you've got a mismatch identification number, that you have to have the same person signing both. That it has to be the same signature. So if a person provides assistance to another person, that you'd have to have the same signature between the application and then the return envelope. So there's really this whole the voter thing. We're certainly not taking away the ability for people with writing disabilities to get assistance with their ballots, and that would clearly violate this court's decision in Ray DSCC, which was just decided.
Counsel, I wonder if you could respond to the implication behind one of the points the Secretary made about the timing of this challenge, the 14-year, since enactment sort of comment. And, we have had a number of general elections, obviously, since that bipartisan compromise was reached and this rule was promulgated. And so I am kind of curious as to what your response would be. This isn't a laches defense, but kind of is there something in the record here, either before us or in the public record, that would indicate that ballot boards are using the Secretary's rule in an inappropriate way, or is this just more related to, general concerns about ballot integrity? Just curious.
So I think the clearest, in terms of specific reasons, I think that, as Justice Thiessen mentioned earlier, there are a lot of situations in which you simply wouldn't be able to figure out if the ballot board is using it wrong. But the time difference between the original rule and the challenge, I think mostly has to do with the increasing use of absentee balloting in the state of Minnesota. The fact is, and I think we in our principal brief, we go into the rise of absentee balloting. Even in this last midterm election, you still had an increase from 2018 midterms in absentee balloting. And 2020, we know was at 1.9 million out of 3.3 million in the state were absentee. You have a lot of ballots that are being looked at absentee-wise now. So it has really come to the forefront, in part, I think, because of the increase in absentee balloting. And as we note in our brief, in the principal brief, there is whether justified or not, there is a concern among many Minnesotans that absentee balloting doesn't have enough security surrounding it. And because of its increased use, that becomes more of a problem. I think that generally answers the question as to why now as opposed to before. Frankly, if I had not been in law school still when this law was passed, maybe I would have brought this challenge in 2010. I don't know. So I also do want to briefly mention that, the biggest problem I see with the Secretary's rule here in interpretation is that it does create this, what appears to me, result of the exception swallowing the rule. And again, you know, we are looking at a situation where you have different names, you have different initials being used or nicknames being used, and that creates a huge problem. There's a lot of moral hazard associated with that, and the rule is not supposed to take away what the legislature has done in providing discretion for people to use their common sense. I would urge the court to look at my quote from the block quote I put in the reply brief from the case where this court decided that jurors could actually do signature matches using their good judgment, common sense, and experience, and they could be actually entrusted with a person's liberty based on allegations of forgery, that they could be put in jail because of a determination by jurors that this person has actually forged a signature. I think, yes, Your Honor.
Oh, I was just sort of interested because I read that and it said because of, you know, the use of traveler's checks and credit cards, we're all so good at looking at signatures, and I thought, whoops.
Yeah, well, I still have to sign credit card statements every now and then. So, and there's a lot of Minnesotans obviously who grew up doing that the same way as that we all did. And it may not be with Venmo anymore quite as prevalent.
So can I just ask a question?
Yes.
So under this rule, when it says use of initials or lack of initials, is that only saying if it's Paul Thiessen and then Paul C. Thiessen, or is it saying I could do PCT?
I don't know.
I guess I should have asked the secretary that. I'm sorry,
I think that's a big part of the problem, is that I just don't have a good answer for that. We don't, like I said, it causes a ballot board member who's looking at it, and this is what our clients have alleged in the petition, in this case, that where they're in a position as ballot board members and election judges, by the way, all three of them, that they don't feel like they can necessarily comply with the statute because the rule tells them they can't reject a ballot based on these kinds of exceptions.
You could certainly reject a ballot if it had a different middle initial, like, for example, Margaret H. Chudich, and another one says Margaret A. Chudich.
Well, I don't know if the rule allows that. Again, I don't see that in the rule. But I would think if the court were to so hold, I would agree with that. I agree that the ballot should be rejected in those circumstances, assuming that there's not like just a typo.
Maybe not Chudich, because that seems to be one of a kind.
Let's not go down that road. Are your red light's on?
Yes, I just asked the court to declare the rule invalid, and I thank the court and counsel for your time.
Thank you, counsel. Thanks to both counsel for the help you provided to the court in this matter. This case is submitted. We'll issue an opinion in due course. We're in recess.